Welcome to the Open Meeting Law Potpourri webinar with the Data Practices Office. Thank you for joining us this morning. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We also record our webinars, so if you missed part of today's discussion or want to go back and watch it again or find one of our prior series, they are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing these resources after the webinar. If you'd like to download a copy of the PowerPoint right now, I will share the file for you to download and save to your computer. Okay. So that file should be popping up on your screen now. That should appear, and then you can select the file to download to your device. Again, don't worry if you can't see the file transfer. I can certainly try and share it later again at the end of the webinar, or you can find a copy of the slides on the webinars page on the Data Practices Office website. Okay, today's webinar is going to focus on the open meeting law. We'll start with a review of the advisory opinions the Commissioner of Administration issued during the past year that addressed open meeting issues. After that, we'll highlight various questions our office has received recently about the law, and as always, we'll hold a Q&A session before wrapping the webinar. So please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure to choose all panelists when you send your questions so that we can be sure to see them. You can start sending the questions now, or you can wait until the end of the presentation. Before getting started though, I do want to highlight a few online open meeting law resources that are already available to you. First, I want to remind folks that we do have a recorded webinar from last year that provides a high-level overview of the open meeting law's various requirements. If you are interested in learning the basics of the law or are merely searching for a refresher, I recommend watching that recording of our webinar from January 2023. The Data Practices Office website also has several web pages with guidance about the open meeting law's various requirements. These pages include information about how public bodies can close meetings appropriately, how to provide notice for different types of meetings, the requirements that public bodies must meet if they conduct a meeting using interactive technology, as well as a discussion of some of the different myths and misconceptions about the requirements of the open meeting law. Additionally, you can find substantial guidance about the open meeting law in the various Commissioner of Administration advisory opinions, all of which are available on our website. We do have a function for the opinion library that allows you to search by keyword, topic, public body, or opinion number. You can also filter the search results to only display open meeting law opinions. Of course, you can always reach out to our office directly by email or phone if you want to discuss specific questions you have about the open meeting law's requirements. So first up, let's walk through the open meeting law advisory opinions that the Commissioner of Administration issued in 2023. But before directly jumping into those opinions, though, I do want to provide some key reminders about the advisory opinion process related to open meeting law issues. First, the Commissioner's authority to issue advisory opinions is found in Section 13.072, which allows members of the public to request an advisory opinion when they disagree with how a public body is performing its duties under the open meeting law. Public bodies themselves may also request an advisory opinion on any question relating to their open meeting law obligations. However, I must note that the Commissioner will not accept an advisory opinion request when there is an intra-body dispute among members of the public body or between the public body and its administrative staff. Additionally, the state legislature amended Section 13.072 last year to remove the $200 required fee to request an open meeting law opinion. This change brings the open meeting law opinion process in line with the process to request a data practices opinion, which hasn't required a fee for more than 25 years. As a result, the open meeting law advisory opinion request process is more accessible to members of the public and smaller public bodies that may have found that $200 fee to be a barrier when seeking more formal guidance about the law's requirements. As for the opinions themselves, the Data Practices Office received 14 unique requests in 2023 for an open meeting law advisory opinion. As a reminder, the Commissioner's authority to issue advisory opinions is discretionary. So the Commissioner will not typically accept opinions when the requester is simply asking for general guidance about the open meeting law, when there are factual disputes over what happened in the situation, or when there's not enough information to determine whether an open meeting law violation occurred. So the Commissioner accepted 3 of those requests and subsequently issued an opinion. In the remaining requests where the Commissioner did not issue an opinion, the Data Practices Office staff offered informal guidance and information to the requesters about the open meeting law's requirements. In short, we do offer some type of information or assistance to everyone who requests an advisory opinion from the Commissioner. So to the opinions, and the first opinion we're highlighting this morning is Advisory Opinion 23-003. In this situation, a city council announced it would be holding a special meeting, and in the special meeting notice, the council stated that the meeting's purpose was to discuss issues including parking, future land purchases, ethics issues, a side-by-side for the police department, as well as the fire chief's salary. The city council then held the special meeting and discussed the noticed topics. However, the council members also discussed other issues during the special meeting, including topics related to affordable housing, the schedules of on-duty police officers, regulating short-term rentals in the city, as well as some additional topics. Members of the public requested an opinion, and the commissioner agreed to address the issue of, did the city council provide appropriate notice of its special meeting? The short answer, no. The City Council did not provide appropriate notice of the special meeting. Specifically, Section 13D.04, Subdivision 2, requires a public body's special meeting notice to provide sufficient detail about the meeting's purpose, which is the intended object or end to be attained during that meeting. Furthermore, a public body's actions are then limited to those topics that it included in the notice of the special meeting. Here, the City Council acknowledged that it discussed additional issues that were not specifically described in the special meeting notice, but the Council maintained that these issues were part of the broad discussions involving the notice topics. The City Council added that many of the discussions on the additional issues were limited or anecdotal in nature. However, the Commissioner disagreed, noting that many of the additional issues did not directly relate to or mention the appropriately noticed topics. The Commissioner also explained that the fact that the discussions about the additional topics were limited or anecdotal did not relieve the Council from its obligations to appropriately notice all topics it would address during the special meeting. Ultimately, the City Council's failure to notice all topics resulted in the public not knowing which subjects the Council would discuss during the special meeting, and members of the public could not reasonably determine whether they should attend the meeting to learn council members' views on these issues or have access to the council's decision-making process. Lastly, the commissioner addressed the council's argument that it did not transact public business during the meeting because council members did not make motions and no public business occurred, which appeared to suggest that the additional discussions outside the scope of the notice were permissible under the open meeting law. The commissioner noted that the Minnesota Supreme Court determined that the open meeting law's requirements applied to any gathering of a quorum or more of a public body's members when they discuss, decide, or receive information as a group on issues relating to the body's official business. This definition does not require a public body to transact public business or make and vote on motions in order for the open meeting law's requirements to apply. Ultimately, the key takeaway here is that public bodies must ensure that they are noticing all topics that will be addressed or discussed during a special meeting. If a topic isn't described in the purpose of the special meeting notice, the public body should wait until a subsequent regular meeting or schedule another special meeting to discuss those other topics. Let's turn to our next opinion, which is Advisory Opinion 23-004. And this opinion involved data practices issues and open meeting law issues, but we're going to discuss only the meeting aspects here. So, in this situation, a city council held a closed meeting, citing section 13D.05, subdivision 2B, which allows a public body to close a meeting for preliminary considerations of allegations or charges against an individual subject to its authority. The public body then held several additional closed meetings over the course of subsequent months, and the body continued to cite section 13D.05, subdivision 2B, as the basis for closing these meetings. The individual who was the subject of these meetings then requested an advisory opinion. Specifically, the issue the commissioner addressed was whether the city council complied with the open meeting law when it held closed meetings for preliminary considerations of allegations or charges against an individual subject to its authority. So the commissioner's opinion was that the city council did not comply with the open meeting law when it held additional closed meetings after the council determined that discipline may have been warranted against this individual, and when it discussed additional issues during those closed meetings that were unrelated to the preliminary considerations of allegations or charges against that individual. In the analysis, the commissioner noted that public bodies must close one or more meetings for preliminary consideration of allegations or charges against an individual subject to its authority. However, past advisory opinions clarify that the authority to close meetings under this provision ends when the public body determines that any discipline of the individual may be warranted. Once a public body determines that discipline of any nature may be warranted, the subsequent meetings or hearings related to those allegations or charges against the individual must be open to the public. In this situation, redacted recordings provided to the commissioner as part of the opinion request indicated that the city council had determined during its first closed meeting, if not earlier, that discipline of the individual may be warranted. The recorded discussions of subsequent closed meetings also indicated that the city council discussed hiring a temporary replacement, theorized that issues related to the allegations and charges would cease if the individual was no longer employed with the city, and strategized about how to notify the individual about the pending termination. All these topics went beyond the scope of what would be considered preliminary considerations of allegations or charges against the individual, and therefore the city council was obligated to have these discussions during an open meeting. As a result, it was clear that the closure of several meetings was not permissible under section 13D.05 subdivision 2B after the city council's determination that it would likely discipline the individual. So the big picture takeaway here is that public bodies can certainly hold meetings to conduct preliminary considerations of allegations or charges against an individual subject to its authority. However, when the discussions move to the individual's performance or potential replacement or removal, the public body has moved beyond those preliminary considerations because it appears some type of discipline against the individual may be warranted, and any additional meetings must be open to the public. Let's turn to the last opinion we'll be discussing this morning, and that's Advisory Opinion 23-005. Here, there was a city council that closed a meeting to discuss litigation strategy regarding its contract with a local school district to provide school resource officers, and whether the city should break that contract. The city council closed the meeting, citing section 13D.05 subdivision 2B, which permits a public body to close a meeting for the purposes of attorney-client privilege. However, the opinion requester provided information from the school district, which indicated that the district had not threatened litigation. The requester explained that city officials and the school superintendent discussed issues related to the contract prior to the meeting, and that the district had said that it was not threatening litigation, but wanted to learn what the city was doing because it may impact school resource officers at different schools. So the commissioner agreed to address the issue of whether the city council complied with the open meeting law when it closed a meeting on the basis of attorney-client privilege. In reviewing this situation, the commissioner opined that the city council did not comply with the open meeting law when it closed its meeting for the purposes of protecting attorney-client privilege. In the analysis, the commissioner noted that the Minnesota Supreme Court established the test for the appropriate application of the attorney-client privilege exception to close a meeting, explaining that the purposes served by the attorney-client privilege must be balanced against the purposes of the open meeting law. As a result, the attorney-client privilege exception to the open meeting law applies only when the balancing dictates the need for absolute confidentiality. As a result, the scope of the attorney-client privilege is narrower for public bodies than it is for private clients, and would not apply in situations when the public body is merely seeking legal advice from an attorney. Further, the threat of litigation alone is not a sufficient reason to close a meeting for attorney-client privilege purposes, nor does the fact that the consequences of a public body's decision, one way or the other, could prompt litigation justify the closure of a meeting. Here, the commissioner understood that the city council's discussion of the contract and a decision to break it could have resulted in potential litigation against the city at some point in the future. However, at the time of the meeting, there did not appear to be any threatened or pending litigation against the city, and the threat that litigation could be a result of the city's decision one way or the other did not justify closing the meeting. Therefore, the public's right to hear the council's discussion about the contract outweighed the council's need for absolute confidentiality. Therefore, the city council did not comply with the open meeting law when it closed its meeting, citing attorney-client privilege in order to discuss that contract. In short, the big takeaway here is that public bodies need to remember that there are limited circumstances when they can close a meeting for attorney-client privilege purposes, and they should do so only when absolute confidentiality is necessary. Okay, that was a highlight of the recent advisory opinions addressing open meeting law issues. Again, you can find these opinions on the Data Practices Office website, and I'd encourage you to read them to gain a full understanding of the analysis the Commissioner provided in each situation. Now, let's turn to the potpourri portion of the webinar, where we'll answer some of the interesting questions we've seen come up in the past few months. So let's start with a question about closed meetings, which is who can attend a closed meeting of a public body? For example, can a staff member attend when they are the subject of the closed meeting, such as situations when the body is reviewing that individual's performance or conducting preliminary considerations of allegations against the individual? The open meeting law is silent about who may or may not attend a meeting that a public body has properly closed. As a result, the public body itself can determine who should attend closed meetings. Obviously, who the public body may allow to attend a closed meeting will likely vary based on the reason for closing the meeting and the assistance the body may need during that closed meeting. That said, there's a few considerations that the public body should probably keep in mind about closed meeting attendance. First, there are situations when the subject of a closed meeting can request that the meeting be open to the public, and the public body is obligated to comply with that request. Specifically, these situations include when a meeting will be closed for preliminary considerations of allegations or charges against an individual subject to the public body's authority, or when the body is evaluating the performance of an individual who is subject to its authority. There's no specific process in the law for how the individual can request that meeting be open. So our guidance is that public bodies should take practical steps to inform an individual that they will be the subject of a closed meeting and provide a reasonable amount of time for the individual to exercise the right to request the meeting be open. Again, if such a request is made, the open meeting law states that the meeting must be open, and the public body no longer has authority to close the meeting. Second, public bodies should think carefully about who is permitted to attend a closed meeting. Although the law doesn't specifically describe or limit who can attend closed meetings, the public would reasonably start asking questions about the necessity of closing the meeting when the number of people who attend such a meeting increases. In other words, more people attending the closed meeting will likely result in more questions about whether the public body is being transparent. Our best guidance is that a public body should limit attendance at closed meetings to only those individuals who absolutely need to be there. The second question we have today is whether there is an open meeting law violation when a public body chair meets with another member of the public body, as well as members of the administrative staff. For example, is it a violation when the chair of a school board meets with a new school board member and the superintendent to provide an overview of the school board's work and the various issues that come before the board? The answer to this question really depends on the makeup of the specific body in question and whether the board chair and additional member are a quorum of that public body. If the chair and member make up a quorum of the public body, the meeting would be a violation if it wasn't properly noticed and open to the public. However, if the chair and member are not a quorum of the public body, there would be no need for a notice, and any such meeting wouldn't be subject to the open meeting law's requirements. When it comes to this analysis, the key thing to remember is the guidance the Supreme Court provided about what is considered a meeting that is subject to the open meeting law's requirements. Specifically, the court clarified the open meeting law applies to gatherings of a quorum or more members of the governing body at which members discuss, decide, or receive information as a group on issues relating to the official business of that governing body. So, one-off meetings between two members of a public body and administrative staff are not subject to the open meeting law when the two members do not make up a quorum of the full body. However, once there are enough members in attendance to make up a quorum, then all the open meeting law requirements come into place. All right, the next question we've seen a few times in different variations. The city council is going to hire a new city administrator. Can the city council close its meetings to review applications and then again to conduct interviews of the finalists? In short, this question revolves around whether a public body can close meetings when discussing personnel data and issues. The answer to this question is no. The City Council cannot close its meetings to review applications and conduct interviews for the city administrator position. There's not language within the open meeting law that permits a public body to close a meeting for general personnel issues, and therefore the council meetings to review applications and conduct interviews must be open to the public. I think this question does come up because public bodies and government entities recognize that a hiring process involves reviewing and discussing sensitive private personnel data, and the body wants to ensure that such sensitive data isn't improperly disclosed to the public. So here are some tips and reminders for public bodies to help address these concerns. First, remember that Section 13D.05, Subdivision 1B, states that not public data, which includes private personnel data, may be discussed during a meeting without penalty so long as the disclosure is related to a matter within the scope of a public body's authority and is reasonably necessary to conduct the body's business or agendas items. Obviously, hiring key administrative staff are within most public bodies' authority and would be related to agenda items, meaning that discussion of applicant data and conducting interviews would fall within this exemption. Nonetheless, public bodies may still have concerns about unnecessarily disclosing additional information about applicants. So one method to help address these concerns is to use pseudonyms for the various applicants being reviewed rather than names. For example, board members can refer to the applicants as applicant 1, applicant 2, applicant 3, and so on, rather than John Anderson, Maria Gomez, and Jenny Kim. Additionally, there will likely need to be some data about applicants that must be included in the public packet that's required to be available in the meeting room. However, public bodies should remember that much of the data in applications and resumes will be classified as private personnel data, and they should redact any specific data that are not designated as public under Section 13.43, Subdivision 3 in the Data Practices Act. Government entities may also want to provide information in the job posting to alert potential applicants that the hiring process for the position will be conducted by a public body, and as a result, discussions about their applications as well as the interviews will happen during meetings that are open to the public. The inclusion of this information can allow applicants to make informed decisions about whether they wish to participate in a hiring process that will be conducted in front of the public. Lastly, we've heard concerns about the fairness of a process when interviews will be conducted during an open meeting, which may potentially allow some candidates to hear questions before it's their turn to be interviewed. So, a few suggestions here. First, the public body may want to schedule all interviews during a single meeting to help ensure that there's less opportunity that any one candidate has extra time to prepare because the interviews are conducted at several meetings different days apart. Second, the public body can consider sharing the interview questions with candidates ahead of time to help ensure that no specific candidate can be advantaged by hearing questions during an earlier interview. For example, the public body can send each candidate the questions approximately a day before the meeting, which allows all candidates to have roughly the same amount of time to prepare. Lastly, public bodies can certainly ask candidates to refrain from attending the portions of the meeting where other candidates are being interviewed as a way to assist with the integrity of the hiring process. Of course, a public body probably cannot prohibit an applicant from attending the other interviews, but it may be a worthwhile conversation to have with the candidates that the body is considering hiring. Okay, our fourth question that we've been getting a little more often involves special meeting notices. The question is whether public bodies can simply post special meeting notices on a website or a social media site as a more efficient way to inform the public about the upcoming special meeting. So I think we can all agree that social media or websites can be a helpful tool for public bodies to reach constituents and stakeholders. However, it is not sufficient for a local public body to post a special meeting notice only on a website or social media site when it comes to meeting the requirements under Section 13D.04, Subdivision 2. Rather, a local public body must post the special meeting notice on the body's principal bulletin board, or if the body does not have such a bulletin board, then the notice must be posted on the meeting room door. Additionally, the special meeting notice must be delivered to each person who has filed a written request for notices of special meetings, or alternatively, the public body can publish the notice in the official newspaper of the body at least 3 days in advance of the meeting. Again, it's likely helpful when local public bodies post a special meeting notice online, and we'd certainly encourage them to do so. However, these public bodies must also remember to follow the language of Section 13D.04, Subdivision 2, so that they do not violate the open meeting law. One last caveat here, though, for state level public bodies, posting a special meeting notice on their applicable state website or in the state register will meet the special meeting notice requirements within Section 13D.04. Again, this is only for state level public bodies, and local public bodies, such as cities or school districts or counties, need to post the notice on the bulletin board or meeting room door. The next question we have is about the public packet of board member materials that must be available in the meeting room for inspection. Specifically, a public body has a scheduled presentation during its meeting, and the presenter provided each public body member with a sheet that outlined her major points. So the question we have is, did the public body need to add a copy of that handout to the public packet? The quick answer is yes. The public body needs to put a copy of the handout in the public packet that's available in the meeting room. As a reminder, Section 13D.01, Subdivision 6 requires that at least one copy of any materials that are related to the agenda items of the meeting that are prepared or distributed by or at the direction of the public body or its employees and are distributed at the meeting to all members of the public body, excuse me, distributed at the meeting to all members of the public body must also be available in the meeting room for public inspection while the public body is considering the subject matter. So that's a lot of public. So in other words, if a presenter hands out materials to members of the public body during the presentation, then that handout should also be available for inspection in the public meeting packet. So as a practical step, public bodies should ask for all presentation materials and handouts prior to a meeting to help ensure that staff can place the documents in the public meeting packet. Alternatively, the public body could ask the presenter to bring additional copies of any handouts to place in the public packet. Of course, there will always be situations when a public body may not realize that they will be receiving a handout. So the commissioner has previously opined that if this type of situation comes up, a public body should briefly recess in order to make a copy of the handout that can be placed in the public meeting packet to ensure that it's meeting the requirements of the open meeting law. All right, here's our final potpourri question of the morning. A public body is planning to have several guest speakers at an upcoming meeting, and it is planning to reserve the space in the regular meeting room for the guests who will be presenting during the meeting. However, there will still likely be members of the public who wish to attend, so the public body's plan is to direct members of the public to a different room where the meeting will be broadcast for members of the public. The question is whether this type of setup is permissible under the open meeting law. So there's not a yes or no answer to this question because the open meeting law is silent on this type of issue. There's no specific language in the open meeting law that states a public body can knowingly limit the number of members of the public who can attend a meeting. Additionally, there's no case law that addresses this type of issue either. However, public bodies should keep a few different considerations in mind in this type of scenario. First, the language of Section 13D.01, Subdivision 1 states that all meetings must be open to the public. Further, the Supreme Court has noted that the open meeting law should be interpreted in favor of public access because the law was enacted to benefit the public. Further, the court has added that the law should be liberally construed in order to protect the public's right to full access to the decision-making process of public bodies governed by the open meeting law. So we can't say definitively how a court might rule if someone alleged this type of practice violated the open meeting law, but it's probably safe to say that all public bodies should be very careful if they are limiting the public's ability to attend a meeting within the meeting room. Any such restrictions should be as limited as possible and reasonable within the context of the situation. Our practical guidance is to always take steps to avoid placing limitations on meeting attendance and do so only when it is absolutely necessary. If there does need to be a limitation on attendance, a public body should ensure there is still reasonable access to the meeting. Some considerations to keep in mind might be whether there are larger meeting spaces the public body could move the meeting to, such as a community center, a gymnasium, the local armory, or other large space that could accommodate more people where the public body members are located. Whether the public body has sufficiently informed the public in advance that space may be limited in the meeting room and ways to alternatively access the meeting, and whether the topics during the meeting are controversial in nature or will raise substantial interest for the public, resulting in an appearance that the public body is limiting attendance in order to avoid scrutiny or access to decision making. This isn't an exhaustive list of things to consider, and these are merely just some considerations that public bodies should keep in mind to ensure that meetings are as accessible as possible for the public. Of course, there may be different considerations if many people show up to a meeting unexpectedly and fill the meeting room. A court may be a bit more forgiving if the body attempts to reroute attendance on the fly, so it's probably helpful to always be ready with overflow space if you know that the audience space in the meeting room could fill up very quickly. However, courts may not be as lenient if a public body knowingly limits the public's attendance at a meeting when other reasonable steps could have been taken to ensure the public was able to fully exercise its rights to observe the body's decision-making process. So those are our questions for today. Let's take some time to discuss the questions you all have, and remember to send those questions to all panelists so we can make sure our staff is able to see them. And as you're sending in the questions, just a few reminders on this slide that the slide deck is available on our website and you can access the recording on our YouTube page in the next day or two. I'll also be putting an evaluation in the polling panel here shortly. If you would please fill that out and let us know how we did, what other topics you'd like to see in the future. As we're preparing to answer some of those questions, I will also take a moment to share the PowerPoint slides once again right now.
Right, while the poll is being posted and the download is being posted, I'll jump in here with our first question. We have a question that says, does the second advisory opinion we discussed mention the ability to close a meeting for attorney-client privilege after the determination that discipline may be warranted was made. Put another way, how does the ability to close a meeting for attorney-client privilege interact with the mandate to open that meeting? That's a great question. I think that they are separate, and so the opinion itself doesn't address that just because that was not raised in the fact pattern. But I think that the attorney-client privilege exception is still available, with the caveat that the Supreme Court has been very clear that the exception would almost never apply to what it termed general legal advice. I don't know what that means, but that's something to consider, and that it should rarely be used except in situations of threatened or pending litigation. And so it is the attorney's determination as to whether or not they have met that standard. The Supreme Court, again, has been very clear that it's not going to have a bright line rule. So whether it's threatened or pending litigation or somewhere before or after that, does not automatically mean that you can close the meeting for attorney-client privilege or under that exception. So for the attorneys here online today, you're really going to want to dive into Star Tribune versus HRA and Prior Lake American versus Mater, because those are the two cases that really lay out the scope. And again, that scope is narrower, as the presentation said, than for, say, private clients. So the exception, the attorney-client exception is to the open meeting law is narrower, then you might use it in other contexts. So definitely take a look at those cases. But in general, to your question, I think that it's still available should those personnel matters come to a litigation situation.
Okay, another question that we have here related to Potpourri question number 3, which was the public bodies interviewing, going through the interviewing process. Could members of the public body interview candidates in a number less than a quorum? And so that's a great question, and there's a few things to keep in mind with this. And so if there's less than a quorum of the public body members that are gathering to discuss business, then the open meeting law requirements do not apply. And so if it's less than the quorum of the public body members, then the open meeting law requirements don't apply. But public bodies should keep in mind on that specific process. There is a case, I believe it's Mankato Free Press versus the city of North Mankato. Those are the two parties involved, where I believe the city council there had some sort of process where they were kind of doing group interviews in less than a quorum of different folks, and there was questions over whether or not that could potentially be a serial meeting. And what the court had said in that case is, certainly that process frustrated the open meeting law and kind of the intent of the open meeting law. But really what they needed to get more information about was whether or not that was the intended purpose of those types of serial meetings. And so if you're setting up some sort of process in order to have, let's say it's a 9-member public body and you just have, 3 interviews with, groups of 3 members at a time, that could potentially be a serial meeting if, the purpose is to kind of circumvent the open media law. So just keep that in mind. But if it's just simply saying, hey, we're going to just have our, 2 members or the board chair decide on who the city administrator would be, seems unlikely. But if that were the process, say, hey, it would be the board chair and the, chair of the employee committee, and it's just those 2 members, and they decide to interview the candidates and then make suggestions, that might be a process. But again, I would say be careful about adding those types of different kind of caveats, because that may appear to be circumventing the open meeting law through a serial meeting process.
Okay, another question is, do paper copies of presentations shared on screen need to be printed for the public in the public packet? This is also the only way the city council sees them. That is a very good question. It's a very practical, modern question. Unfortunately, the open meeting law, not a very modern law. And so the requirement in Chapter in 13D.01 subdivision 6 does generally refer to printed materials that are distributed. I think that there's an advisory opinion that would also include emails in that. So if emails are sent out to people then that are public, that those should be available in the public packet. So I think that the law itself contemplates a paper packet in the room, kind of as the presentation talked about, putting the notice on the meeting room door or on the bulletin board. These are aspects of the law that just have not been brought forward into contemporary business practices. And so the legislative session is coming up. So I encourage everyone who's listening to this, if that's something that they think should be changed or made clearer, that would be great to add to the law. But the law itself, as I said, contemplates a printed copy in the room. The other question that I will just follow up on is somebody asked if I could please repeat the names of the attorney-client privilege exception cases, excuse me, and they are the Star Tribune versus HRA, and that is a case from 1976, and the Supreme Court identified the exception before it was codified in law, in the early 2000s, and then it was litigated again in Prior Lake versus Mader, M-A-D-E-R. Sorry, Prior Lake American, it was a media outlet versus Mader, M-A-D-E-R, in 2002. And essentially the Supreme Court there just said, we already recognize this as exception. It's fine that it's in the law. It just needs to be interpreted in the way that we already said in HRA. But definitely those are the cases that we look to when thinking about the balancing test and whether or not it's appropriate under the open meeting law exception to close a meeting under attorney-client privilege.
And I will just add there that both of those cases are cited along with kind of their citation, so you can find them a little bit easier in that advisory opinion 23-005. So if you go to the text of that opinion, that should be right there and available for you, and you can find those pretty quickly. I am also going to quickly open the poll here, so if you'd be willing to fill that out. But in the meantime, we still do have a couple minutes left to answer questions. And we still do, and so yeah, if you're hearing silence here, it's because we don't have any questions coming through, and so we're certainly happy to give it a few more minutes here quickly. So feel free to send those in to all panelists if you have them.
About that, I will jump in and again and say that the legislature is going to begin their work next month, and we are hearing about some possible proposals to change the open meeting law in various ways. So for all of those, for those of you who are working under this law and interested in this law, definitely keep your eye on those. We will track all the changes, and they will be available if you're interested. Someone's asking if their CLE credits are available today. There are, and the code was posted on the initial slide, but you can email us and we can send it out to you.
All right, so I think we're kind of running out of steam with the questions here, so I will just kind of start wrapping up here. Thanks for attending today and sending in your questions. As a reminder, we do have trainings coming up in the next few weeks. Unfortunately, they are filled up or pretty near being filled up at this point. But we do have an Intro to Data Practices remote workshop next week. And then the one that is filled up is the Advanced Data Practices workshop that focuses on personnel data redaction. And those workshops, the information about those workshops are on the Data Practices Office website. So if you are interested in those, we do offer those workshops fairly regularly. And I know we'll be offering both of those again sometime in the near future. So keep your eyes open for that. Lastly, if you're not already signed up for our email list, I'd encourage you to do so on our website. That's where you can receive information on new webinars and workshops as they are scheduled. And we also send out a newsletter every other month about data practices and open meeting law issues. So thanks again for joining us this morning, and have a great day. Thanks.